Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. So I've had some people ask, can you cover some more self-defense related cases? And often what people want to know is they want some very simple rules for what they can and can't do in self-defense. People often ask, if somebody's breaking into my house and I have a firearm, can I use that in self-defense? And they're typically not very happy when my answer is, well, it depends, or maybe. And sometimes they'll say something like, well, what if they have a knife? What about then? And the answer is still, well, it depends and maybe, because self-defense is what lawyers call fact-specific. And in fact, it's very fact-specific, which means it comes down to very complicated details of a particular event. So it's hard to give a general rule because so many things get weighed by the court in terms of ultimately deciding the issue. But the way you sort of untangle that is by looking at some cases. And this one is kind of a wild one in terms of the facts, so I thought it would be a fun one to go through. This is the Queen and Kyle Sparks McKinnon. It's an Ontario case. It's a very recent Ontario case. The decision just came out in 2021. So let's have a look here. So the judge notes, Mr. Sparks is charged with the second-degree murder of Charles Shillingford. Isn't that a great name, Charles Shillingford? It sounds like an alternate name for the Monopoly guy. Anyway, carrying on. Mr. Shillingford was shot in the early morning hours of October 31st, 2015 on Charles Street in the city of Toronto. Mr. Shillingford drove away from the scene of the shooting, but eventually crashed his car on Yonge Street, south of College Street. Mr. Shillingford was alive after the crash, but succumbed to his wounds soon after. If you want to play a little game as we go, you can consider all of the different people who appear in this, because there's a number of different people, and just think, how many of these individuals have a firearms license? Just something to ponder as we go through. All right. So we see Mr. Sparks was charged in relation to this offense in 2016. His trial proceeded before me without a jury over several months in 2020. Mr. Sparks testified at his trial and admitted fatally shooting Mr. Shillingford. He testified that he acted in self-defense. He testified that he exited his car before the shooting with his loaded gun in hand with the objective of scaring the driver of a car that had just cut off his car. Just as he stepped out of his car, the driver of the other car got out of his car and pointed a gun at Mr. Sparks while uttering threatening words. Mr. Sparks testified that he believed he would be killed and that he fired his gun at the man in order to defend himself. I'm just going to stop here and note that it's a good thing that this one proceeded without a jury for us as people who want to unpack the law. And the reason for that is that if we had a jury on this, what we might see is some commentary on the judge's instructions to the jury, how the judge tells the jury to make their decision, what things they need to consider. But we wouldn't get any sort of detailed analysis of the self-defense issues because all of that would happen in the jury room where the jury is not able later to tell us what their thoughts were. So it's kind of a black box. So because this is just the justice here telling us this or giving us this verdict, we're going to get a lot more detailed unpacking of how they come to the ruling that they do. So Mr. Sparks also testified that he did not intend to kill Mr. Shillingford and that he was intoxicated at the time of the shooting. Prior to the October 31st, 2015 killing of Charles Shillingford, there had been two other shootings involving Mr. Shillingford and Mr. Sparks. On August 9th, 2015, Julian Weekus, that's my best guess at the pronunciation here, a close friend of Mr. Sparks, shot at Mr. Shillingford in the parking lot of Cafe Atlantis, a club in Peel region. Mr. Shillingford was in his car at the time of the shooting and drove away, although he was wounded by the gunshots. Mr. Weekus left the parking lot in a car driven by Mr. Sparks. Mr. Sparks drove alongside Mr. Shillingford on Highway 401 shortly after the initial shooting. Mr. Weekus fired further shots at Mr. Shillingford on the highway. On October 5th, 2015, Mr. Shillingford, or someone acting in concert with Mr. Shillingford, fired shots at Mr. Sparks as he drove his car near his brother's residence. Mr. Sparks testified that when he shot Mr. Shillingford on October 31st, 2015 on Charles Street, he was not aware that he was shooting at the man involved in the previous incidents. And you can decide for yourself if that's something you believe or not. We're going to go through most or many of the facts here. I'm going to cut out some of the stuff just to try to keep this short, try to keep it a little more simple. But it's a bit of a complicated issue, and I can't cut out too much without effectively not making it fair to you guys in terms of trying to understand how the court gets to its reasoning. So let's keep going. So issues. To prove that Mr. Sparks committed the offense of second-degree murder, the Crown must prove beyond a reasonable doubt that Mr. Sparks caused the death of Mr. Shillingford, that he did so unlawfully, and that he had the intent for murder. It is not disputed that Mr. Sparks caused the death of Mr. Shillingford. In fact, that was Mr. Sparks' testimony, is that he shot at Mr. Shillingford. If Mr. Sparks was acting in self-defense, the killing was not unlawful. Where self-defense is raised by an accused person, and there is an air of reality to the defense, the Crown must disprove self-defense beyond a reasonable doubt. So this is an important principle of law. There's essentially two hurdles, and the defense first has to reach the hurdle of an air of reality to the defense. Now, that might be through defense evidence, but it can also be through just the Crown's own facts. But what it means is that there has to be some plausible basis to believe that it was a self-defense situation. So as some examples here, if somebody's running at you with a knife and you shoot them, you've got an air of reality there. That part's not going to be a problem. But let's say, there's somebody with a knife and they're a kilometer away from your house and you're pretty sure they're coming to do you violence, but you are using a rifle, you're a really good shot, and you pick them off a kilometer away. You're going to have some real problems on the air of reality issue there, because, how are you going to establish an air of reality to shooting somebody who's a kilometer away armed with a knife? Even if they are a world champion knife thrower, they're still not lobbing that thing a kilometer. Most people couldn't necessarily shoot the kilometer away. So that's an issue of air of reality. If you're at a bar and somebody pulls a knife on you and you use violence to stop them, you've probably got an air of reality. But if you walk into that same bar and go up to somebody who's just sitting there enjoying a drink and shoot them in the back of the head, and that's seen by a whole bunch of witnesses, you're not going to be able to establish the air of reality. So that's the first hurdle that the defense has to reach. But once they hit that hurdle, and it's a low bar, it's basically just, is this defense not crazy town? Is it plausible that it could be self-defense? Once the defense sort of reaches that point, then self-defense is on the table, and it becomes a thing that the Crown has to prove the opposite of. The Crown has to disprove self-defense. So if the court is left saying, well, we really think that this was an intentional killing for no reason, but it could have been self-defense, that's still plausible, it's still possible, I've got some doubt on that one, then they have to acquit. The Crown has to prove that it was not self-defense beyond a reasonable doubt. So that's a tough burden for the Crown. All right, so continuing on. The issue in this trial is whether the Crown has disproved self-defense beyond a reasonable doubt. Section 34 of the Criminal Code sets out the elements of self-defense, as set out by our Court of Appeal in the Queen and Cahill. And I'll just note here that that decision is currently under appeal at the Supreme Court. I have a video about that. You should check it out if that's something that interests you. I'll try to remember to link it when I'm uploading. So paragraph 42, self-defense under section 34 has three elements. First, the trigger, which is a bit of a pun in the context, but I don't think that was the intent. The accused must believe, on reasonable grounds, that force is being used or threatened against him. Note, it's that the accused must believe on reasonable ground. That doesn't necessarily mean that the accused has to be right. So as an example of this situation, let's say you're out in the woods and somebody, you see somebody with a rifle and you see that rifle is pointed right at you and they're firing. You might believe on reasonable grounds that force is being used or threatened against you. even if it turns out later that, in fact, this hunter hasn't seen you at all and has seen a deer that's way behind you and is shooting at the deer and just hasn't seen you. They've got, scope blindness. They failed to properly, check their firing path. But you might still believe that that person is trying to kill you. And it might be a reasonable belief under those circumstances where you see somebody pointing a rifle at you and firing. So that's sort of an important distinction, is that it doesn't have to necessarily be true that that's what they're doing. So the motive, the act of the accused said to constitute the offense, must be done for the purpose of defending himself. This is not usually going to be a big problem, but, if you think, hey, I don't need to defend myself, but I still just want to kill this guy anyway, then you're going to have motive problems. The response, the act said to constitute the offense must be reasonable in the circumstances. So this is a big, complicated question that involves a whole lot of sub-factors, and we'll get into how the court deals with this one as we go. So if there's an air of reality to the defense, the burden of proof is on the Crown to disprove at least one of these three elements beyond a reasonable doubt. In this case, the Crown argues that I should reject the evidence of Mr. Sparks that Mr. Shillingford was pointing a gun at him. The Crown's position is that the evidence supports the finding that Mr. Shillingford was shot while he sat in his car, and that Mr. Shillingford did not ever remove his own gun from his pocket. Therefore, the Crown submits the first element of self-defense, that Mr. Sparks faced a threat of force from Mr. Shillingford, has been disproven beyond a reasonable doubt, and the defense of self-defense fails. What this means is that the Crown is saying that Mr. Sparks, when he got up on the stand to testify as to his defense, the Crown is saying that he was lying. The Crown is saying, don't believe him. This is not what happens. And that Mr. Shillingford never got his gun out. That he was just shot and he had a gun on him, but he never managed to draw. He was killed before he managed that. So that's one reason why they're saying not self-defense. And you can see that if the Crown is right about that it doesn't become a self-defense situation, most likely, unless there's some reason. There might be still situations where that might still get you to self-defense, but it'll be a lot harder than if somebody's got their gun out. If I have a reasonable doubt that Mr. Sparks faced a threat of force from Mr. Shillingford, the Crown concedes that there would also be a reasonable doubt on the second element of motive. So Crown says, if he had a gun out and if he, that was being pointed at Mr. Sparks, we agree that motive isn't going to be a question. This is a very reasonable concession from the Crown, so good on them. However, the Crown's position is that even if there is a reasonable doubt with respect to the first two elements of self-defense, Mr. Sparks' act of shooting Mr. Shillingford was not reasonable in all the circumstances, and the third element of self-defense has been disproven beyond a reasonable doubt. So the Crown's saying, even if Mr. Shillingford had a gun and was pointing it at Mr. Sparks, he shouldn't have shot. I'll let you decide if that's sort of where you think, and the court will see very quickly how they come, because they give their decision ahead of time here. So we're going to be seeing what the ruling is. Therefore, the issues in this case are, 1, has the Crown proven beyond a reasonable doubt that Mr. Sparks did not believe on reasonable grounds that force was being used or threatened against him? And 2, if the answer to the first question is no, has the Crown proven beyond a reasonable doubt that Mr. Sparks' act of shooting Mr. Shillingford was not reasonable in the circumstances? So it's cut it from 3 things to consider really down to 2 because of that Crown concession. And the ruling is that, for the reasons that follow, I have concluded that the Crown has not disproven the elements of self-defense beyond a reasonable doubt. The Justice says, in the reasons that follow, I will first set out the facts that are not in dispute. I will then review the evidence with respect to the disputed facts, my findings of fact, and finally the application of the relevant legal principles to the determination of the issues in this case. Now, I really like it when the judge starts out by giving their verdict. Some judges don't do this. Some judges leave that to the end. But it's always nicer when we know what the decision actually is, so that then we can read the evidence in that context. It's also way nicer if you are the accused, or even if you're just the accused lawyer or the Crown, because, there's a lot to this. And in fact, often these decisions are going to be read out in court. it really sucks for the accused if they're sitting there listening for, 30 minutes or longer to determine if they're actually being convicted or acquitted. I think it's a lot fairer and a lot sort of nicer to everyone involved to present that ahead of time. All right. So facts that are not in dispute, and I'm going to really skim all of this because I'm trying to keep this video to not super long. So Cafe Atlantis shooting. There was a shooting that occurs at the Cafe Atlantis. That involves Mr. Sparks and Mr. Weekus. Mr. Weekus takes a shot at Mr. Shillingford in the parking lot of this cafe. Mr. Shillingford takes off driving away. He tries to leave, and he gets onto Highway 401, and somehow this vehicle being driven by Mr. Sparks and with Mr. Weekus in the passenger seat somehow manages to catch up with him on Highway 401. Mr. Sparks denies that he's deliberately following or deliberately pulling up beside Mr. Shillingford. That seems like a heck of a coincidence. But anyway, and then they fire again, or Mr. Weekus fires again at Mr. Shillingford, who suffers an injury to his left shoulder, wounds to his neck, but he doesn't die. He remains alive at this point. And this is kind of a key point here, they say, in his interview with the police following the shooting, Mr. Shillingford indicated that he intended to seek out information about the identity of the people responsible for the shooting. So do you think he was just curious? Like, hey, that's a neat thing. I wonder who did that. I wonder who shot me. That'd be a nice thing to know. Or do you think maybe he had some inclination to solve problems himself? Maybe he wasn't sort of a law and order kind of guy, but more of a do-it-yourselfer. You can draw your own conclusions on that one. Filming this the evening of my birthday, so I've got a nice glass here. Also, Robbie Burns Day, so little combination of those two things. Brooker Lane shooting, October 5th, 2015. So either Mr. Shillingford or somebody working in concert with Mr. Shillingford takes a shot at Mr. Sparks while he's driving his distinctive white Corvette on Brooker's Lane near the residence of Mr. Sparks' brother. So, and this is a place he's known to be. So this seems like the little conflict between these individuals might be heating up a little. I mean, there's now gunfire being traded. How do you think this story is going to end? Do you think this story is going to have a happy ending? Obviously, we know it doesn't. But at this point, you have to be aware, and everyone involved has to be aware. This story doesn't end happily, and we can draw some conclusions about the people who are choosing to engage in this particular lifestyle here. So, brass rail shooting, October 31st, 2015. I'll note that a lot of self-defense cases involve people who very much position themselves to be in danger in life. And, that's not uncommon because they're more likely to get shot at and more likely to sort of need self-defense. I have been shot at few times in my life, and that few times is a nice 0. And that's really the number of times I would like to be shot at in my life is 0. I don't consider that to be a positive thing. I don't think that's something that I would like to add to my life. But for some people, their life choices make that a much higher risk, as we can see in this particular set of facts. So brass rail shooting, there's an exchange here. I'm cutting out a lot of it because a lot of this is kind of somewhat inconsequential how things get to happen here. But here we have an important part. At 2:10:30, Mr. Desmond handed something to Mr. Sparks. Mr. Sparks testified that while the item appeared to be weighted and was consistent with a gun, Mr. Sparks' recollection was that he already had a gun in his possession all night. He did not recall receiving a gun from Mr. Desmond. So Mr. Sparks says he got this gun from Mr. Weekus, not from Mr. Desmond. But there's video footage that shows him getting handed something. And, he says, sure, that looks like it could be a gun, but it's totally not a gun. The court's going to have some comments on that. All right, skipping over the nitty-gritty of all of the timeline here. Miss Todorovsky, and she's a dancer at the brass rail. She can be seen on a video taken inside the brass rail to be on her phone. And she appears to react and jump up at about 2:22:53 a.m. She is at this time on the phone with Mr. Shillingford. So the reason why this appears to react and jump up at this particular time is important, is that it kind of provides us a time when this shooting probably happened. She leaves the brass rail still on her phone and runs southbound on Yonge Street. She's visible running across the intersection at Yonge and College Streets at 2:31:40. All right, Mr. Shillingford's car can be seen on a camera taken from Yonge and College Streets traveling south on Yonge Street, ultimately crashes south of the intersection at about 2:24 a.m. It's an agreed fact that a witness, Mr. Hugh, I'm guessing, who was driving southbound on Yonge Street, approaching College shortly before the crash, saw the Chrysler approach from behind his car really fast. The Chrysler crossed the center line to pass another car, and then passed Mr. Hugh's car before proceeding through a red light and then losing control and crashing. Mr. Shillingford was alive and mumbling after the crash, but he was incoherent. Mr. Shillingford died shortly afterwards from his gunshot wounds. So this is also an important bit. He doesn't die right away when he's shot. He has some time to get back in his car and drive away, but doesn't last all that long. Mr. Shillingford was in possession of a mini Glock handgun on October 31st, 2015. I'm guessing this is just a small model Glock. I'm not going to guess which sort of variety. I'm guessing it's not like one of those 2-inch novelty pinfires that are sold. I don't think they make those in Glocks in any event, but we can take from this it was a functional, this thing would be dangerous to people around him. After his death, medical personnel handed over to police a down vest that was worn by Mr. Shillingford. The gun was found in an inner zipped pocket of the vest. And that's going to be an important detail. The Crown is going to be relying on this detail quite a bit. Post-mortem examination disclosed that Mr. Shillingford was struck by 2 bullets. One bullet entered his left posterior upper arm and exited the left medial upper arm, so hit him through the arm. The bullet re-entered at the left axilla / lateral upper chest, or approximately below the left armpit area. The direction of the bullet in the body was back to front and left to right. The other bullet entered mid-back, and the direction of the body was back to front and left to right. Mr. Shillingford died from internal bleeding caused by the gunshots. Now, one thing people sort of assume is they hear that a bullet entered from the back, and that they say that this necessarily means that this can't have been self-defense. But that doesn't actually fit in practice, and the reason why is what you'll see is that when people get shot at and they start seeing that somebody's sort of pulling the trigger and aiming at them, they start turning away. They turn away from the gunshot, and so often those shots can land in unexpected directions and unexpected trajectories, such that even somebody who might be facing square on, just as a gun is being drawn, end up getting hit, sort of in the back and shoulder, that kind of location. So that doesn't necessarily mean a whole lot, but it's important to know if you're a person who likes reading these kinds of accounts. So post-offense conduct. Mr. Manette, who's another individual in this whole wild story, drove the Buick Regal to another province on the day after the shooting. Mr. Sparks, in his testimony, admitted that he was aware of Mr. Manette's intention to get rid of the car. The gun used to shoot Mr. Shillingford was not recovered. Mr. Sparks described getting rid of the gun with the assistance of Julian Weekus. So, post-offense conduct is relevant because there's a general assumption, usually, that, if you're an innocent person, you're not trying to hide the, what happened. So if somebody, breaks into your house and, is coming at you with a fire axe and you end up having to shoot them, it's going to undermine your self-defense claim if you have gotten rid of the body and, tried to clean the blood off your floor and so forth. All of those things can very much be detrimental to a later self-defense claim. I'll probably do a video just on that issue because there's a persistent thing that keeps coming up in the firearm community that I'll probably address. So skipping over some of the details on the Cafe Atlantis shooting, that's really historical. We'll skim over that. I'll try to see if I can find this on a publicly available site so that you guys can check it out if you want to. A lot of the facts here aren't super important for our purposes. But Brooker Lane shooting. One of the first times Mr. Sparks took out the Corvette after the shooting at Cafe Atlantis was on October 4th, 2015, when he and his brother went to the Sundowner, a club in Niagara Falls. He dropped his brother back at his brother's residence in the early morning hours of October 5th, 2015. As he left the area near his brother's building, a man shot at his car. As indicated above, it is admitted that the man who shot at Mr. Sparks was either Charles Shillingford or someone acting in concert with him. Mr. Sparks denied in his testimony that he knew who was shooting at him. He agreed that at the time he thought it could be related to the shooting at Cafe Atlantis. He tried to determine the identity of the person who shot at him. He testified that he had no success. Mr. Sparks went to speak to Julian Weekus to glean any information about the man from the Cafe Atlantis shooting. Mr. Weekus was not able to tell him who it was. However, Mr. Weekus did provide Mr. Sparks with a gun. He told Mr. Sparks that the gun was ready to go, and by this Mr. Sparks believed that he meant that it was loaded. Mr. Sparks denied ever checking the gun to see if it was loaded, and he denied ever firing the gun before he used it on October 31st, 2015. He testified that after receiving it, he always carried the gun with him when he went out. So this is a disputed fact, but this is how Mr. Sparks says he came to have the gun. All right. He also denies that he ever learned the identity of the man who had shot at him or at whom Mr. Weekus had shot through these contacts. So he says, I never knew who it was. We just had this shooting with somebody and I never managed to find out. So the brass rail shooting, which is the critical one, I'm going to skip over a whole bunch here, but they note Mr. Sparks looked at the video surveillance showing the apparent exchange of an object between he and Mr. Desmond, which took place in the back parking lot of the brass rail after he left the club. This would have been happening on the stand. This would have been probably in his cross-examination. He testified that while it appears that something was exchanged, he recalled that he had his gun the whole night and he did not receive it from Denzel Desmond behind the brass rail. He recalled having the gun in his waistband throughout the night. He testified that immediately prior to getting out of the car and shooting Mr. Shillingford, the gun was in his front hoodie pocket, and then he held it on his lap. He did not recall when or why he moved it from his waistband to his hoodie pocket, or precisely when he took it out of his hoodie pocket. All right. After they were in the car, Mr. Sparks testified that another car began tailgating them with its high beams on. Mr. Manette said, "Oh, this guy's right on my ass." Someone said it was the police, and Mr. Manette kind of pulled over to the side. As he started to pull over, the other car cut in front of them and slammed on the brakes. Mr. Manette slammed on his brakes and almost hit the other car. Mr. Sparks could not say what street they were on when the Chrysler cut them off. He recalled it occurring seconds after they had started driving. Someone said it was a black Chrysler. After it cut them off, it drove off quickly. Mr. Manette followed the other car. This is not generally a smart move. I see lots of files that start out with, somebody is a total jerk to you in traffic, and so I decided to follow them and have a confrontation, and it's about even odds as to who ends up the winner of that confrontation. It's often not the person who does the following. So this is a great way to make a life choice where you are risking your safety. I recommend against this particular course of action. If somebody has been a jerk to you and is leaving, let them leave. That's always the safest method. People ask me about self-defense all the time. One of the critical things of self-defense is not to get into situations like this. My advice for self-defense is that most people who get killed in these kinds of scenarios did so because they made a series of choices. that led to a situation where ultimately violence was inevitable. So that's this. We're seeing those choices right here. Mr. Sparks did not remember the path taken by the vehicles. He recalled that after the Chrysler cut them off, someone said that it hit a taxi and there was a taxi following the Chrysler. At some point after this, someone in his car said, "There's the guy," and Mr. Sparks saw the Chrysler 300 stopped at the side of the street. Mr. Manette pulled up behind the Chrysler. According to Mr. Sparks, everyone in the car was pumped up, saying things like, "Let's go, let's go." Mr. Sparks testified that they were going to go and rough him up. He recalled someone saying, "I'm going to fuck him up, this asshole." Hopefully YouTube doesn't complain too much about that particular use of language, but I'm going to have to paraphrase some bits that come up very shortly. Mr. Sparks did not think that the person in the car was the person who had previously shot at him. He believed that it was some random guy downtown driving crazy drunk or something. At the time that the car stopped, Mr. Sparks' gun was in the pocket of his hoodie. Just before getting out of the car, he took the gun out. He testified that he intended to brandish it and scare the driver of the Chrysler. Mr. Sparks got out of the car and turned. He saw the door of the Chrysler open, and when the man got out, Mr. Sparks saw that the man had a gun. He heard the man yelling something like, "Phrase involving the N-word," or "phrase involving the N-word again." So he's really clear on that particular word, but the actual phrase doesn't seem to make a whole lot of sense. Hold this N-word, or hold this BN. So Mr. Sparks screamed no, fired his gun at the man, and jumped back in the car. Mr. Sparks testified that everything happened very quickly. He believed that the man was going to shoot him. He testified that, like the way he got out of the car, he was coming towards us, and right away, as soon as he got out of the car, I could see the gun. Mr. Sparks also described it this way. Everything was like in the same distance, like the same everything happened all together. Just like as I got out of the car, I could see his door fly open, and as soon as I turned around, he was already, like I saw his gun coming towards me, like he was already pointing it towards the vehicle, and once I heard him scream, "Hold this BN," I just shot. Mr. Sparks testified that he aimed in the direction of the man in the car. He tried to jump back into the car at the same time. He did not intend to kill the man. I'm just going to note here, I've never heard anyone testify that things happen slowly. People always say, "This happens so fast." And because, of course, once your adrenaline is going, everything feels like it's super fast. And a lot of these violent confrontations, they last seconds, not minutes, not hours. You know, they're over very quickly. Mr. Sparks did not remember seeing any other occupants of his car outside the car. He saw Mr. Desmond getting ready to get out just before he did, but he did not see him outside the car. Mr. Sparks testified that he did not move past the passenger rear door. He used the door as a shield and fired from behind it. Practical tip, your car door doesn't stop anything. It's not quite tissue paper, it might, but it's not going to be a reliable shield. You know, if you see people in the movies hiding behind a car door, no. Bullets will pass right through that, especially on modern cars where, you know, the paneling is probably plastic rather than, you know, metal. But even on a metal car door, it's not a good shield. After the shooting, Mitchell Manette drove them away. Mr. Sparks testified that he passed out in the car. He woke up at home. He learned the next day that the man in the car was Charles Shillingford and that he had died. Mr. Manette told him that he would take care of the car. Mr. Sparks contacted Mr. Weekus, and Mr. Weekus drove to an area near Lake Ontario where they threw the gun into the lake. So, they're getting rid of the car, they're getting rid of the gun. Skipping over a bunch of things here. Mr. Sibalski, again, I hope, described the shooter as a black man with medium skin color, around 6'1" or maybe a bit taller, with an athletic, slim build, late 20s into his 30s, with black hair buzzed down short, and with a hairline straight across his forehead and no facial hair. He described the sweater worn by the man as a blue sweater, between a light and dark blue, a little bright, about waist length, crew neck color, possibly made of wool. So lots of details. When he was being shown a clip of Mr. Sparks and the other men, which was taken that night, he did not recognize any of the men as being the man with the gun. Okay, so maybe those details aren't helping him out as much as we thought. He said that he was looking for the blue sweater and did not see it. He distinctly recalled that the sweater had no zipper or hood. It was a crew neck sweater. The blue sweater worn by Mr. Sparks that night had a zipper and a hood. So he's got lots of details. They're just not right. Mr. Sobalski agreed that the events happened within seconds. He had consumed 6 beers over 6 hours before he observed the man on Charles Street. He was tired and the lighting was dim. Because of these factors, he was unsure of his observations. He also agreed that he and Mr. Stewart had discussed some aspects of the event before they went to the police. He knew that Mr. Stewart recalled the second car as being dark, while he believed that it was white. Again, his details are all wrong. This is very common. We tend to think, an eyewitness is the gold standard for evidence. But eyewitnesses are actually pretty terrible a lot of the time. And we can see that, this eyewitness has lots of detail. He's providing this story full of, a rich narrative. It's just wrong on all of these different points. So Matthew Stewart testified that when he heard 3 loud bangs, he looked west and saw a car pulled over on the north side of Charles Street facing west with a man standing beside the car on the driver's side. The man was within a few feet of the driver's side door. He described the man as a black man with light brown skin, average build, 5'7" to 6'3" tall, wearing a lighter colored shirt, possibly a light blue shirt or sweater with a dark jacket or hoodie over it. As noted above, Mr. Sparks wore a blue hoodie that night. Mr. Shillingford wore a dark vest over a shirt. And so you see that there's a description here from Mr. Stewart, but that description describes a whole lot of people. It's a black guy, okay, that's helpful. Average build. Everybody turns out to have an average build when witnesses describe them, almost always. And a height range that includes the majority of men. Wearing a lighter colored shirt, which he can't give us any details on. So again, eyewitness identification, not super awesome. This is a constant thing that shows up in criminal law. It's a big source of wrongful convictions. So, has the Crown proven beyond a reasonable doubt that Mr. Sparks did not believe on reasonable grounds that force was being used or threatened against him? So the Crown's theory is basically that Mr. Shillingford never got his gun out, and if he never got his gun out, then maybe, Mr. Sparks, maybe he didn't even see it. Maybe it's just a situation where he was ticked off and annoyed and just walked up and shot the guy because he was ticked off and annoyed, and because, Crown's version is he's a bad dude. We think that this guy is a real serious criminal and that he needs to be in jail. All right. So the justice says there are, in this case, 2 competing versions of the events on October 31st, 2015. Mr. Sparks' version is that he set out to scare a stranger who had cut them off by brandishing a gun at that person. The stranger then threatened him with a gun, and he had to shoot the man in self-defense. The threat and the shooting occurred when both men were outside their respective cars. The Crown submits that Mr. Sparks, knowing who Mr. Shillingford was, followed Mr. Shillingford's car and then shot Mr. Shillingford as he sat in his car. He did so in retaliation for the October 5th, 2015 shooting by Mr. Shillingford. Which kind of makes sense. If you've got somebody who's shooting at you and trying to kill you, maybe you might want to kill them first. So the Crown's position is that when Mr. Sparks' evidence is considered in the context of the whole of the evidence, it should be rejected and that it should not raise a reasonable doubt. The Crown submits that Mr. Sparks is not credible. His account is implausible and inconsistent with the other credible and reliable evidence in this case. In short, the Crown says he's lying. Because the Crown bears the burden of proof, my task is not to choose between the 2 competing versions of facts urged upon me by the Crown and the defense respectively. Mr. Sparks does not bear the onus of proving self-defense. The Crown must disprove it. This is quite correct. The justice is quite properly interpreting the law here. In assessing the credibility and reliability of the evidence of the accused, Kyle Sparks, I must assess his evidence in the context of the whole of the evidence. I must consider the internal consistency of his account and the consistency with other evidence. I must consider any inherent implausibility in his account. So even if you're not contradicted, if you're saying that it wasn't you that shot the guy. A unicorn came out of nowhere, grabbed your gun away from you, fired 2 shots into the guy, and then handed you the gun back. That would be an inherent implausibility in this account. There are not that many unicorns running around. I may take into account Mr. Sparks' criminal record in assessing his credibility. I may accept all, some, or none of his evidence. It's not just that you believe him, wholesale. You can say, I believe he was telling me the truth here and not the truth here. This is actually the case for just about all witnesses. Most people are at least wrong about something. Even honest witnesses can be wrong about something. And, it's very rare that people are just such liars that you can't believe any of the stuff they say. Even where they say, I find that this guy was on the stand trying to lie up a storm, they'll say, well, I still believe him when he says, that he left the house, got into his car at this time, when he was going to this bar, that kind of thing. It's usual that some evidence is accepted and that some is rejected for just about every witness. With respect to the Cafe Atlantis incident, one significant inconsistency in the account of Mr. Sparks is his assertion that he came upon Mr. Shillingford's Porsche on Highway 401 by chance. Mr. Sparks' evidence was inconsistent on the question of where he intended to go after leaving Cafe Atlantis and why he was traveling west on Highway 401. It does not make sense that Mr. Sparks was intending to go home and take Mr. Weekus home, but then went the wrong way on Highway 401. It does not make sense that he was going to his brother's residence, but was taking Mr. Weekus with him. I do not accept his evidence that he encountered the Porsche on Highway 401 by chance. It is highly improbable that he went the wrong way and then by chance overtook the same car that his passenger had just been shooting at. It is also highly improbable that after the shooting of the white Porsche moments earlier, Mr. Sparks did not notice a white Porsche on the highway traveling slowly because of damage until he was overtaking the car. I do not accept that he did not notice the car until he was almost next to it. While I cannot make a finding about the motivation for the Cafe Atlantis shooting, I find that, at least on the highway, Mr. Sparks was a willing assistant to Mr. Weekus. And it's relevant here that we're talking about a Porsche. If it was, a Honda Civic, well, there's lots of Honda Civics out there. They're not a very distinctive vehicle. But a white Porsche, there's just not that many of them on the road. And so the judge is basically saying, I don't buy your story here, not in the least. I think you went out to finish that job. You were trying to kill that guy, and you gave it your best go. So another aspect of the evidence of Mr. Sparks, which is problematic, is his insistence that he did not recall receiving a gun from Denzel Desmond a short time before the shooting. I do not accept Mr. Sparks' evidence on this point. I find that there was an exchange between Mr. Sparks and Mr. Desmond behind the brass rail, and that the exchange was the handing over of a gun. I do not accept Mr. Sparks' evidence that he did not recall the exchange. Mr. Sparks was clearly unwilling to say anything in his evidence that would incriminate one of his friends. He incriminated only Mr. Weekus, who is now deceased. So if you're wondering why Mr. Sparks was being so willing to talk about Mr. Weekus, he's died somehow. Anyone want to put any money on how he died? Didn't think so. I accept that Mr. Sparks was somewhat intoxicated the night of the shooting, but I do not accept that he has no memory of the exchange with Mr. Desmond. I find that Mr. Desmond retrieved the gun from the car and handed it to Mr. Sparks in the parking lot of the brass rail, which might suggest that he thought he had work to do here. So the aspect of Mr. Sparks' testimony that is central to my determination of the issues in this case is his account of the actual shooting of Charles Shillingford. I have approached this part of his testimony with caution in light of his lack of credibility on aspects of the August 9th, 2015 Cafe Atlantis shooting and his lack of credibility with respect to the exchange of the gun in the parking lot. So having found that he lied about some things, it makes sense he might be lying about other things, but it's not a guarantee. The court still has to assess that. I've also kept in mind Mr. Sparks' criminal record. That record includes youth criminal justice findings for offenses against the administration of justice, and one adult failure to comply conviction. Most convictions, however, are either dated or have little impact on credibility. So your criminal record can impact credibility, but some charges are going to impact it more than others. So, for instance, if you have a lot of fraud charges, that suggests that you are a person who lies habitually. If you have perjury convictions, well, that suggests that you are somebody who is willing to lie in court and has been convicted of that. But, if you have an assault conviction, you got into a bar fight and you punched somebody, that doesn't necessarily mean you're a liar. So that's what the court is saying here, looking at that. I've also assessed Mr. Sparks' version of the events leading to the shooting in light of his evidence that he was intoxicated by drugs and alcohol. I accept that Mr. Sparks consumed a considerable amount of alcohol on the night and morning leading up to the shooting. He can be seen drinking fairly steadily over the time that he's at the brass rail. He's not visibly staggering in the video, but it does provide some support for his evidence that he consumed alcohol and that he accompanied Mr. Desmond to the washroom to consume cocaine. With those observations in mind, I turn my findings of fact with respect to the shooting outside the brass rail. I find that Mr. Sparks was in possession of a gun after receiving it from Denzel Desmond in the parking lot of the brass rail at 2:10:30 a.m. He and his 3 companions then stood near the Charles Street entrance to the Green Pea parking garage until the interaction with Cynthia Todorovsky, which began at about 2:14 a.m. and ended at about 2:17 a.m. I'm going to skip over most of that just because, while it's some interesting drama, it doesn't tell us a whole lot about the shooting itself. So, while I find it suspicious that Mr. Sparks' car ended up following Mr. Shillingford, the man who shot at Mr. Sparks 26 days earlier, I cannot conclude that this occurred because of any plan or maneuver by Mr. Sparks. I'm not able to find that Mr. Sparks knew the identity of the man in the Chrysler. It would be speculative to conclude that Mr. Sparks became aware of the identity of the driver and then lay in wait on Hayden Street, knowing that Mr. Shillingford would pass by and could then be followed. Mr. Sparks' explanation that the car cut them off is supported by the evidence of Mr. Shillingford's aggressive driving on Yonge Street and by the fact that the Chrysler had to have overtaken the Buick on Hayden Street. So that's the evidence of Mr. Jug, or however that's pronounced. So the court is saying, I don't buy that this was an ambush. It seems like Mr. Shillingford was actually driving like a jerk. The account given by Mr. Sparks that he stepped out of his car only briefly and did not approach Mr. Shillingford's car is not consistent with the evidence of the 2 witnesses, Christopher Sobalski and Matthew Stewart. Mr. Sparks insisted that he did not move past the rear passenger door of the Buick when he shot Mr. Shillingford. Both Mr. Sobalski and Mr. Stewart testified that, after hearing 3 gunshots, they saw a man generally matching Mr. Sparks' description in the middle of the street, turning from an area near the driver's door of a dark sedan and tucking his gun in his waistband or front pocket as he moved eastbound on Charles Street. Neither man could define precisely what was meant by middle of the street. They saw the dark sedan drive away. Mr. Sobalski initially said that he saw the man pointing the gun at the driver's side door and then turning. He admitted in cross-examination that, with respect to this aspect of his testimony, he had not made the observation but was piecing things together. In considering the evidence of Mr. Sobalski and Mr. Stewart, I have instructed myself on the inherent dangers of eyewitness testimony. I found both witnesses to be sincere and honest. So what this means is they're trying to tell the truth. Both said that they avoided looking at the man with the gun as they walked closer to him because they did not want to attract his attention. Good move. Generally speaking, it is worthwhile avoiding attracting the attention of people who have firearms, particularly when those people have those firearms illegally, and especially when they've just shot another dude. So neither man would have had more than a few seconds to make observations. Both had consumed some alcohol earlier in the evening. The events occurred very quickly. Mr. Sobalski conceded that because of the speed of events and the conditions of his observations, he could have been mistaken. Mr. Sobalski agreed that the man in the first car that sped off could have been out of his car before Mr. Sobalski made his observations. Mr. Stewart could not say with certainty how far the man with the gun was from the car. He could not attest with certainty the sequence of events. So again, they're honest witnesses. They're trying to tell the truth. They just have crappy evidence. It's fairly common that we get sort of honest but mistaken witnesses who are doing their best to tell the truth. They just don't know and maybe didn't quite see things. Neither man saw what had happened before the shots were fired or as they were fired. Their observations after the shots were fired were made from a distance and at night. They both deliberately looked away as they got closer to the area. In light of the conditions under which these witnesses made their observations, I cannot rely on their evidence to find that Mr. Sparks approached Mr. Shillingford's car before firing his gun. I've considered the evidence of the timing of the shots and the departure of the cars. I have also considered the evidence of the location of the wounds to Mr. Shillingford and the trajectory of the bullet recovered from the Chrysler 300. The wound paths provide little assistance with respect to the location of Mr. Sparks or Mr. Shillingford at the time of the shooting. The wound paths support the inference that Mr. Shillingford raised his left arm and turned just before the shots were fired. What I was talking about. People tend to turn away from getting shot. Not that turning away does anything against a bullet, but it's just instinctive. When you see something dangerous coming towards you, you try to turn away and avoid it. This could have occurred inside or outside the car. Regardless of whether Mr. Shillingford was inside the car or out, he would have had to contort his body to be struck by the bullets in the manner the wound paths suggest. The bullet that entered through the C-pillar of the Chrysler was fired from behind the car. This could have occurred if the initial two shots were fired through the window, wounding Mr. Shillingford, and Mr. Shillingford then drove away with the last shot fired at the car as it left. It could also have occurred if all three shots were fired from behind the Chrysler while Mr. Shillingford was outside the driver's door. The evidence of the location and trajectory of the bullet is not inconsistent with Mr. Sparks' account of the shooting. So you see here, it's not, that it's definitively consistent. It's just that we can't prove from this forensic evidence that Mr. Sparks is not telling the truth. The Crown argues that the timing of the Chrysler 300 driving away immediately after the shots were fired is not consistent with Mr. Sparks' account. It would take some amount of time for Mr. Shillingford to re-enter his car, put it in drive, and leave after the shots were fired. Mr. Miyake's evidence is that the car went through the intersection seconds after Mr. Miyake heard the shots. Mr. Stewart and Mr. Sabalski also testified that the car drove away quickly after the shots. This evidence of the speed of Mr. Shillingford's departure was a subjective assessment by the witnesses. So, subjective as opposed to something that they have on video or the like. I cannot find that the reliable evidence of timing is inconsistent with Mr. Sparks' account. The shooting likely occurred at around 2:22:40, based on the reactions of people in the Green Pea pay station. The Chrysler went through the intersection just before 2:22:57. This allowed approximately 10 to 15 seconds for Mr. Shillingford to re-enter his car and drive away. I cannot say that this was an insufficient period of time for Mr. Shillingford to re-enter his car and drive away. I mean, you got to figure, there's a guy with a gun, you've just been shot a couple of times, you're going to be in a bit of a hurry. I think that I would be incentivized to move my car pretty fast, having been shot a couple of times. Now, the flip side of that is that having been shot a couple of times, maybe he's not going to be the best at getting his car moving. But ties go to the defense here. The Crown's burden to prove. So if there's this kind of confusion, maybe one thing, maybe the other, that helps out the defense more than it helps out the Crown. Crown has also argued that I should reject Mr. Sparks' version of events because Mr. Shillingford's gun was found in the inner zip pocket of his down vest. It is argued that this is inconsistent with Mr. Sparks' evidence that Mr. Shillingford had his gun drawn and pointed at Mr. Sparks before Mr. Sparks shot him. The Crown argues that it makes no sense that a person who has just been shot and is trying to escape his assailant would be concerned with putting away his gun and zipping the pocket. Now let's stop here. Does that make sense to you? I mean, if you've got an illegal handgun on you, because again, I think the chances that Mr. Shillingford was a licensed PAL holder who also had an authorization to carry, I think those chances are about zero, maybe a little less than zero. It's just, that's not what we're looking at here. So, that just makes no sense to me. I don't see how that can possibly be justified. So that's, we've got a situation where this guy's got an illegal handgun. Clearly, to my mind, what he's going to want to do with that is not get busted for having the illegal handgun. So to my mind, it makes perfect sense that he would want to hide that. But We can consider some other possibilities. Let's say Mr. Shillingford had been hit square in the forehead and dies instantly on scene. If you find his gun zipped in his inner pocket when he's, dies on scene instantly, then it probably suggests that he never got the gun out. So, court says, I agree that it is logical that a person who has been shot would use his strength to escape and to get help, not to conceal his own gun. However, I'm of the view that it would be dangerous for me to base findings of fact on assumptions about what a person would or would not do after being shot and fleeing from the person who shot them. Do you think you make carefully considered decisions in that circumstance? I'm thinking no. Your decision-making is going to be impaired both by the adrenaline and by the fact you've been shot. And the fact that you are driving away in terror. If you sort of doubt this, get a page of math problems, really simple math problems, maybe like multiplication tables that they use for kids in drilling. Do half the page just sitting there thinking calmly, and then take a hammer and smack your hand, and then try to do the other half while you're sitting there, nursing a sore hand. I guarantee you that your performance on the second half is going to be way worse than your performance on the first half. So that is particularly true in this case. In August, after the Cafe Atlanta shooting, Mr. Shillingford drove away from the shooting. He managed to drive onto the highway, evade a further attack, find his telephone, and call his girlfriend. On his instructions, his girlfriend connected him with his brother. He did not call for police or for medical attention, but directed his brother to his location and traveled to the hospital with his brother. There's an available inference that on that occasion, Mr. Shillingford did not call the police or the ambulance because he needed first to conceal evidence of his own illegal activity. So this whole soap opera has given them an additional bit of data. After being shot outside the brass rail, Mr. Shillingford again drove away. He must have thought he's the luckiest person on the planet. Getting shot twice, and he figures he's driving away from this, everything is great. His girlfriend, Mr. Todorovsky, called him either just before or just after the shooting, and the two were connected by telephone as he drove. Ms. Todorovsky ran south on Yonge Street to College Street, suggesting that Mr. Shillingford communicated his location to her. In the circumstances, I cannot conclude that Mr. Shillingford would not have put his gun away after being shot and driving away. It is an available inference that Mr. Shillingford could have taken steps to conceal his gun, not realizing the seriousness of his wounds. Again, this guy must have thought he's the luckiest person on the planet to get shot at twice in however, a short period, and hit twice and being like, I'm fine. My big concern is I don't want to get arrested. Turns out he wasn't that lucky. His luck had ran out here. Mr. Sparks' post-offense conduct in allowing Mr. Manette to take his girlfriend's car and then going with Mr. Weekus to a location where they got rid of the gun he used is of little assistance in this case. Mr. Sparks had been in possession of an illegal firearm and had used it. His conduct in arranging to dispose of evidence has little probative value on the issue of self-defense. I guess if you're fond of Lake Ontario, there's a free prize in there for somebody. I might have left out which specific lake, although Lake Ontario is not a small lake. If you're going there looking for this particular gun, good luck. I've outlined the central areas of Mr. Sparks' account of events and my assessment of the credibility and reliability of his evidence in the context of the whole of the evidence. As I've indicated, there are areas of Mr. Sparks' evidence that I reject. In particular, I reject his evidence that he played no part in the Cafe Atlantis incident, and I reject his evidence with respect to the transfer of the gun on October 31st. However, having considered all of the evidence, Mr. Sparks' testimony raises a reasonable doubt on the issue of whether Mr. Sparks faced the threat of force from Mr. Shillingford, that is, that Mr. Shillingford pointed a gun at Mr. Sparks and uttered threatening words that caused him to reasonably believe that Mr. Shillingford would shoot him. Note, he's not saying he believes Mr. Sparks. He's saying that it's still possible. It raises a reasonable doubt, even if he doesn't necessarily think, yeah, Mr. Sparks is, telling me the truth here. I do not find that the evidence of the eyewitnesses should cause me to reject the evidence of Mr. Sparks with respect to the shooting in light of the frailties of their evidence. Nor do I find that the evidence of timing, wound paths, or trajectory to be inconsistent with Mr. Sparks' account. Mr. Shillingford's history of animus against Mr. Sparks is supportive of Mr. Sparks' account, as is the fact that Mr. Shillingford was armed. Yeah, it makes sense that Mr. Shillingford might have pulled a gun, given that the evidence that seems to be in no dispute is that Mr. Shillingford had tried to shoot him before. Is it reasonable that he would believe that Mr. Shillingford is trying to kill him when he's tried to kill him in the past? Seems to me it's reasonable. Second element of self-defense relates to the motive or purpose of Mr. Sparks when he shot Mr. Shillingford. Mr. Sparks' purpose when he left the car was to scare the other driver with his gun. His purpose was offensive and not defensive. However, at the point that he fired the gun, his purpose was defensive. The Crown has conceded that if I have a reasonable doubt that Mr. Sparks was facing a threat with a gun, the second element of self-defense would not be disproven. All right, so just a little thing to consider here, a bit of a thought exercise. Let's consider the possibility of it goes the other way. These two have a gunfight, and let's say Mr. Shillingford is the quicker man on the draw, and, quicker and more accurate. So let's say Mr. Shillingford puts a round in Mr. Sparks, and Mr. Sparks dies on scene. Mr. Shillingford would also have a viable self-defense claim, and arguably a much better self-defense claim under the circumstances, because notwithstanding his driving like a jerk, he was followed, he was confronted by a guy with gun. So we get these situations where, in fact, both sides might actually have a viable self-defense claim. Carrying on. Has the Crown proven beyond a reasonable doubt that Mr. Sparks' act of shooting Mr. Shillingford was not reasonable in the circumstances? So this is the third element. Has the Crown, we just went over that. The Crown argues that even if events unfolded as described by Mr. Sparks, the act of shooting Mr. Shillingford was not reasonable in the circumstances. So the Justice quotes the relevant subparagraphs of subsection 34(2) of the Criminal Code, which state, in determining whether the act committed is reasonable in the circumstances, the court shall consider the relevant circumstances of the person, the other parties, and the act, including, but not limited to, the following factors. A, the nature of the force or threat. B, the extent to which the use of force was imminent and whether there were other means available to respond to the potential use of force. C, the person's role in the incident. D, whether any party to the incident used or threatened to use a weapon. E, the size, age, gender, and physical capabilities of the parties to the incident. F, the nature, duration, and history of any relationship between the parties to the incident, including any prior use or threat of force and the nature of that force or threat. F.1, any history of interaction or communication between the parties to the incident. And G, the nature and proportionality of the person's response to the use or threat of force. So the nature of the threat in this case was the threat of lethal force. A firearm being pointed at you is lethal force. The harm was imminent as the two men faced each other, each with a loaded gun. The Crown argues that Mr. Sparks could have retreated by jumping back into the car when he saw the gun. Mr. Sparks conceded in his testimony that he could have done so. I have considered whether there were other means available to Mr. Sparks to respond to the threat of force, including the opportunity to retreat. On the facts in this case, I find that even if Mr. Sparks had re-entered the car, it would not have prevented Mr. Shillingford from shooting at the car and its occupants. Moreover, the events unfolded extremely quickly, and Mr. Sparks made a split-second decision. An accused person cannot be expected to weigh perfectly all of the available options in the heat of the moment. The way this is often phrased is that you are not required to weigh to a nicety the degree of force that is reasonable in the face of an upraised knife. So you have to fall within the bounds of reasonable, but you don't have to get it perfect. It isn't the case that if somebody armchair quarterbacking it down the line can think of a better idea, that you are necessarily going to be convicted. However, if somebody armchair quarterbacking it down the line can think of a better idea, you may end up going through a very expensive and very stressful trial. So there's a bit of a distinction between those two things. The factors enumerated in subparagraphs D and E, the use of a weapon, and the respective physical capabilities of Mr. Sparks and Mr. Shillingford are neutral in this case. Both men had guns, and there was no significant disparity between them with respect to their physical capabilities. Any disparity in physical capabilities would not, in any event, be a significant factor in light of the fact that both men held loaded guns. This is, in fact, one of the selling points of loaded guns. There's the old aphorism of, God made men, Samuel Colt made them equal. Because, you might be a 6'11" bodybuilder with combat training. You're a boxer, you're a kickboxer, whatever sort of martial art. 9mm still works. So I think the court's assessment on this is exactly correct. We don't really care how big these guys are or how little they are. Once they have guns in their hand, that kind of goes out the window. Given my conclusion that Mr. Sparks was not aware of the identity of Mr. Shillingford when the shooting occurred, the factors set out in subparagraphs F and F.1 relating to the history between the parties are not relevant. And if they were relevant, the history between the parties kind of weighs in favor of Mr. Sparks here anyway, because the history between the two parties is Mr. Shillingford is willing to shoot him, and Mr. Sparks is willing to shoot him as well, but that still kind of suggests a self-defense is on the table. Notwithstanding the fact that both of these guys kind of seem like maybe not the best citizens. The factor set out in subparagraph G with respect to the nature and proportionality of the response favors Mr. Sparks in light of the finding that he used lethal force when faced with the threat of lethal force. There's not a whole lot of expectation by the court when you're facing lethal force that you are somehow going to, use less lethal force. If somebody's trying to stab you to death, it's not like, oh, you need to go find a net or something like that. It's, no, game on. But again, super fact specific, so don't sort of import too much of this to your personal circumstances or to decide what you can and can't do. Because again, you can see the facts are getting really careful and really specific as to deciding this. So I'll now address the factors set out in subparagraph C, Mr. Sparks' role in the incident. This is a factor that was introduced by Parliament in the most recent self-defense provisions. Our Court of Appeal considered the meaning of this factor in the Queen and Cahill. Justice Doherty observed, Section 34 sub 2 C introduced a factor into the reasonableness inquiry that had no equivalent under the previous legislation. The court is required to examine the accused's behavior throughout the incident that gives rise to the act that is the subject matter of the charge. The conduct of the accused during the incident may color the reasonableness of the ultimate act. Placed in the context of the evidence in this case, Mr. Cahill's behavior from the moment he looked out his bedroom window and saw that the dash lights in his truck were on until the moment he shot and killed Mr. Stiers had to be examined when assessing the ultimate reasonableness of the shooting. Section 34(2)(c) renders an accused's conduct during the incident relevant, even though the conduct is not unlawful or provocative, as that word was defined in the prior self-defense provisions. The court must consider whether the accused's behavior throughout the incident sheds light on the nature and extent of the accused's responsibility for the final confrontation that culminated in the act giving rise to the charge. It is for the trier of fact, judge, or jury to decide the weight that should be given to the accused's behavior throughout the incident when deciding the ultimate question of the reasonableness of the act giving rise to a charge. In the Queen and Borden, the Nova Scotia Court of Appeal stated that in response to the jury asking whether the aggressor can use self-defense when he starts losing a fight and believes he is in danger, the judge ought to have replied yes. The court went on to observe, if the jury took the view that the appellant had been the aggressor in the incident or had initially assaulted the complainant, they could consider that as a factor as to whether the appellant's actions were reasonable under Section 34(2)(c), the appellant's role in the incident. In this way, a protection is hopefully present to prevent self-defense from becoming too ready a refuge for people who instigate a violent encounter, but then seek to escape criminal liability when the encounter does not go as they hoped, and they resort to use of a weapon. Because again, often when people are losing fights, that's when they pull out a weapon. The role of the accused in the incident is therefore not limited to the role at the moment of the act of self-defense. The context is broader and encompasses the actions of the accused leading up to the confrontation. In this case, by stopping the car and leaving the car with the intent to threaten a stranger with a loaded illegal handgun, Mr. Sparks bears significant responsibility for bringing about the circumstances that led to his need to defend himself. Mr. Sparks' role in this incident weighs against a finding of reasonableness. However, this is only one factor to be weighed in determining if the Crown has disproved reasonableness. So the court says, we don't like Mr. Sparks, and so that weighs against him here. Mr. Sparks was behaving like a jerk. So in weighing all of the relevant circumstances in this case, while I have some serious concerns about the role of the illegal conduct of Mr. Sparks that contributed to the incident, namely, he's got an illegal handgun, he's been beefing with Mr. Shillingford, and although he doesn't necessarily know that this is Mr. Shillingford here, but he's armed himself with this illegal handgun. They get into this confrontation on the street, and he gets out in order to threaten him with a gun. That's not legal activity. That is, in fact, highly illegal activity at the point where Mr. Sparks sort of starts this whole transaction. I'm not able to conclude beyond a reasonable doubt that his act of shooting Mr. Shillingford was unreasonable. I reached this conclusion because the threat that Mr. Sparks faced at the point that he pulled the trigger of his gun was the threat of death. Although he bears considerable responsibility for entering into the confrontation, I cannot conclude, given all of the other circumstances, and in particular the nature and imminence of the threat, that his response was unreasonable. I cannot conclude that he should have risked death because of his role in putting himself in the situation. Parliament has not denied access to the defense of self-defense to a person who breaks the law or conducts themselves in a dangerous manner. The role of Mr. Sparks in this case is a factor that weighs against the defense, but in light of the other factors does not lead me to conclude beyond a reasonable doubt that his act of shooting Mr. Shillingford was unreasonable. Conclusion: for these reasons, I have concluded that the Crown has not disproven self-defense beyond a reasonable doubt. As a result, I must find Mr. Sparks not guilty. All right, if you were playing along at home with the game of how many people do you think had a firearms license here, my best guess is probably zero, none. However, I can't say that for sure. There are some people who might, when I consider all of the facts here, might actually be holders of a firearms license. Can you guess who I'm thinking of? If you thought the eyewitnesses, who were helping out here, it's entirely possible one of them might have had a firearms license, but I think there's zero possibility that anyone else in this transaction had a firearms license. It's just not plausible to me as to what was going on here. All right, so this is a big, lengthy, complicated case. It is a bit of a soap opera. There's multiple rounds of people shooting at each other. There's an ongoing beef. There's so much going on in this one. It's a wild story. You got to think, when you're assessing your own self-defense needs, you got to think, am I living this kind of life? And if you are, I suggest you make some lifestyle changes. Most of us, at any point, we are at some risk of violent attack. Your risk never drops to zero because there's all sorts of jerks out there. However, it's also, you're never really likely to experience the same risk these particular people did based on the choices they made. But consider, let's say you aren't a gun-packing whoever. You're just a person who maybe makes a mistake in traffic. Because Mr. Sparks' evidence was that at the final confrontation that they had here, he didn't realize that this was the guy he had an ongoing, issue with, that he thought that this was just some guy who'd interrupted them in traffic. If that's the case, then it's entirely possible that somebody who is not super morally blameworthy, they might have screwed up in traffic, they might have been driving like, a jerk, but they might have ended up facing this guy hopping out of the car with the gun, and hopefully not hopping out of the car and firing shots, but that's still going to be a terrifying and life-threatening situation. So this one, sort of on balance, kind of provides a fair bit of commentary on, self-defense in our society. A lot of people are also going to be super upset when they look at a file like this and they say, wait a minute, this guy's a total jerk. How come he's getting to walk on these very serious charges on self-defense when I've seen other people getting charged. And as the court says, self-defense is not limited to people who are sort of clothed in righteousness. It's available as a defense both to people who are complete innocents, as well as to people whose activities are a lot, less innocent. That's ultimately a policy question for Parliament, but I don't really have a big problem with that, because that general principle protects not just this guy, and this guy's probably going to get some jail time for the whole, the other things. He's going to walk on the murder, but the other offenses here are likely still things that they're going to proceed with. The having an illegal firearm, the other instance of pointing of being involved in this shooting, that kind of thing, are things that they might otherwise try to proceed on. But if we set up a rule where you can't use self-defense if you have in some way committed a criminal offense, then we end up in a situation where self-defense also ends up being gutted for folks like you or I. Let's say there is, I hear a disturbance, I hear somebody is screaming like they're being murdered in my back alley. And I think, I don't want to just be the guy who ignores this sound of somebody being murdered in my back alley. I really got to go and, and deal with that. And let's say I go and I grab a firearm to investigate this, because of course, if somebody is being murdered, I got tiny, scrawny arms. I'm not going to go out there and, Bruce Lee my way through this. I'm not John Wick. I'm not like, hey, I got a pen, I'm good. No, I'm going to, go out there equipped with something a little, more useful at preventing me from getting killed. And let's say I go out there with a handgun. Now, the court might then say, listen, you didn't have an authorization to transport that handgun or to carry that handgun when you went out into that back alley to see what was going on. And so, notwithstanding the fact that somebody then charged you with a machete and you shot them, because you committed the crime of going out there with the handgun, you don't get to use self-defense. That's not a very satisfying outcome to me. So this is an example of, people say, oh, the law does too much to protect bad people. But the protections of the law that shield the bad people are also the protections of the law that shield good people. We rely on these protections all the time. So I'm not super upset by this case. At the end of the day, it's sad what happened here, and, but I don't want to cut down those legal protections in order to try to get this guy. And we've seen that far too often from our current government, where they say, we don't like this ruling, and because we don't like this ruling, we're going to change the law so it can never happen again. I think that's a really bad way to set up the law. I'm going to cut it off there because I try not to be too political, but I don't like that approach to lawmaking, and I don't think this is a case that anyone should hold up as, we've got to change the law. No, the law's working fine. Don't mess with it. We might not like the outcome all the time, but it's still working fine. Most of the time, it still does what it needs to do. All right. It looks like we are about at an hour and 20 minutes. I'm going to cut it off here. I want to say thank you to my Patreon supporters. This is a largely Patreon-supported channel. Those being Demo, Sir Daniel Wicks of Alberta, Canada's National Farms Association, and Kyle Martin, as well as to my $20 supporters, Cameron Johnson, Kevin Fleet, Dale Nesbitt, and Andrew Elsich, as well as the $10 supporters who will be in the crawl immediately following. I'd go through it, but my throat's starting to get a little sore here. I've been talking for an hour and 20 minutes. And maybe I should have had a glass of water rather than birthday scotch. Anyway, thank you for watching. I really do appreciate your continued support. I hope I've armed you with knowledge. And if you want to see more self-defense cases, let me know in the comments below. If there's something else you want to see, let me know. And until next time, cheers.